Hello, everyone. My name is Mary Heil, and I'd like to welcome you to Protected Tomorrows. Our webinar today is titled Legal Planning in the Special Needs World. And now I'd like to introduce the president and founder of Protected Tomorrows, Anne Ehlert.
Hello, everyone. Glad to have you back. Hopefully you have attended our previous classes, and if not, you can always go back and look at them. I think they're all recorded for you. So we've already covered a couple topics of overview of planning, and we've covered benefits. So today we're going to walk into the legal world. Just as a disclaimer, I am not an attorney. I am talking to you as a financial person and an advocate for special needs. And I want to make sure that you understand the things that an attorney will do for you and what's necessary, how to find the attorney, how to have a good conversation with the attorney, and the kind of things that you're going to be talking to them about. I always find that when I walk into an attorney's office, if I have an understanding of what they're going to ask me in advance, I've had some time to think about it. So let's get going. Those of you who have not been to one of my sessions, here's the reason I do what I do. This is my sister, Marcia. She was 4 years younger than me. She has cerebral palsy, and she was developmentally delayed as an adult. She was about age 8. She lived a nice life. She was able to have some independence. She was able to have a lot of fun. She did pass away just before she was 40. And, many of us struggled through that, but she did have a good life, and I'm thankful for that. But she is also the one who taught me what I'm talking about today, the importance of thinking about the future. And I learned a lot from my parents about how they thought about her life and how they thought about and how they learned about what needed to be done from a legal perspective, and how they learned about what they wanted and what they didn't want. And I had the opportunity to talk to them before they did their legal documents and find out what they did wrong, talk to many conversations with attorneys with them, and then have the ability to chat with them about what they'd wished for my sister's life after she had passed away. So I had lots of different insights over the years, and we've been doing this for about 31 years. So I hope that my class today will help you think about the planning that you're doing. If you've done it already, give some context to it. And if you haven't done it, how to be thinking about it. So those of us at Protected Tomorrows, our mission is your mission. I think it's most of the time it's to have your family member with a special need have a safe life, a fulfilling life. We want them happy, and I hear the word safe and happy a lot. So that's pretty much what we do, is we're trying to prepare you so that you can work and have your child be the best they can be. And we have an 8-step process. We have talked about this in each session. Today we are doing number 3, filter the legal options. And it's helping you think through, if you have thought about what you want, what's the best thing that can happen for your child, which we always start with, and creating that plan and talking about the benefits, which we've covered. And so we're at this step where we're thinking about, how do I put things in place from a legal perspective to make sure that my child's safe and happy. There's lots of information here. We have a website which you can relook at some sessions in the future if you want to. And one of the focuses we have is on the team, because we can't do this alone. We just cannot do this alone. We need our team. So in the center of the team is always the person with a disability, but we want you to have a dream team. We want you to have a coach, which we sometimes act in that capacity. You're going to have trustees and guardians. And in this case, we're going to be talking about both of those. Who's a trustee, who's a guardian, what's their job. And so those people play a key part to this team. And there's all the other people who surround them as well in the social world, the faith world, advocates, doctors, medical providers. We're going to be on the team as well. But today we're going to be talking about the trustees and the guardians. Again, my goal for today is to give you awareness so that you can take action. I want to make sure that when we get done with the class, you've identified some things you need to do, and you'll hear me asking you to share some of those things with me, and creating a list for yourself of the things to be done, because there really is no reason for me to do this except that I want you to take action. I want you to have your plans in place, and I want to give you yourself some peace of mind. So we always start with step one in each class to say, what do you really want? And this helps drive your discussion with the attorney. So the two questions, once again, and if you attended my other classes, you know I will always ask this question: what's the best thing that can happen for your child's future? And what's your biggest fear? Because the legal documents have a big part to play in that, right? We're saying legally what we want. We are addressing the people we want to step up. We are addressing money. We're addressing all of those things. So let's get started. One of the questions I hear a lot is, how much money am I going to need from a family member with special needs? How much is it? And I used to always say, wow, it was a big stack, right? Because I didn't have a process to calculate it. But I think just like we can plan if a child's 2, how much money you need to save for college, we can do the same thing for you when you're thinking about how much you need to save for retirement. And I think about this process is saving enough money for your child's future, including while you're alive and when you're gone. But the gone part is what we're talking about today, is if I'm not here, how do I divvy up what I have? How do I put that in place? Okay. So I call it filtering the legal options, because we have many options all of the time in our lives. And how do we filter out what we should do and what we shouldn't do? So when I first started this practice of helping families, it was about 31 years ago, where I told my parents what I was going to do. And I started talking to them about how they had planned for my sister. And what I learned was I asked them what they had done, and they didn't want to talk about it. And I didn't understand it at all. I understand it now quite well, because I'm a mom of a child with special needs now, and he's an adult. And I understand really thinking, I don't want to talk about it because this person's going to need me around. And so I don't want to talk about my death. It's kind of a depressing thing until you start to realize that it's empowering us to do the things we need to do and make our child's life as best as it can be. So if I want to empower myself to empower my child's life, I've got to be realistic, and I've got to get advice. I've got to get help with an attorney. But my parents just had a hard time addressing the topic. I asked them and I asked them and I asked them. Finally, my father told me that I wore them down, and they did talk about it. And what they had done is they had created a will, and in the will, they disinherited my sister, and they left her share with me. And they said, you're going to take care of her emotionally, financially, and we're leaving the money so that you can take care of her. That's what their decision was. That was the advice they had gotten. And it was the wrong advice, but it was the best advice that was out there, the kind of advice that was out there a lot back in those days. Now there's attorneys who really understand this well. And if they don't, they know how to get you to an attorney who will do it well. But why did my parents do that? They knew that I was very close to her and that I would take care of her. And they also knew that I had a financial background of my siblings. I was the financial person. And so, they left it to me. And what was wrong with that? So I'll tell you what's wrong with that. A, I loved her. And B, I financially would have provided for her. And if my parents had left nothing, I would have done it if I could. But the problem is this: I would be holding money for my sister. So if my parents passed away and they gave me her share, it wasn't mine, except legally it was, right? They gave it to me to hold, but there was no legal recourse to anybody if I used it wrong. Really, it's my money. So I could have gone into Hawaii and spent it on myself. I wouldn't have, but I could have. If I was married, I could have put it in joint tenancy. And then if something happens to me, it's his. Or if we get divorced, it has to be split up in the divorce, right? Because it's our money. If I die, it might go to my children. And they loved my sister when they were little. She was like a mom to them. She was always kind of bossing them around and telling them what to do. And it was a special relationship they have. But as they became adults, they might have said, well, we're going to buy a car with this money. We're going to drive her around in that car, a real cool car. And she would have loved that. But it wasn't the right thing to do. What if I got sued and the money's in my name, right? The money's at risk. If it's mine, all the things that could happen to my money could happen to my sister's money. So it really wasn't the right thing to do, even though it felt at that time from my parents it was. So one of the things we don't want to do is leave money directly to the person with a disability. We learned that in the benefit class, that the most a person who's going to get SSI and Medicaid can have in their name is a house, a car, a prepaid funeral, $2,000, and an ABLE account. Okay, ABLE accounts for the next class, and all those other things, you know, that you shouldn't leave those things to the person with the disabilities. And we also learned that it takes money to provide for that person, right? If we're going to make sure that they're okay for the future, government benefits doesn't provide it all, and we have to leave them money. So if we have to leave them money, but we can't leave them money, and we don't want to leave it to siblings with our fingers crossed that they'll do the right thing, and we can't use regular planning. So I have a trust set up for my other sons, and I do that because I want to protect their inheritance. I want to protect them from themselves, from misusing the funds if they're too young and unable to. I want to protect them until they're more mature and they know how to handle some money that I might leave to them. And that's typically called a spendthrift support trust or a children's trust. We hear it called lots of things. I can't do that for my son with disabilities. My parents couldn't do it for my sister. So they had done things wrong. Any of these other things would have not been a right choice either. Why not the support trust, spendthrift support trust, or a children's trust, like I left for my other boys? Well, if I leave money to my son with special needs in one of these trusts, it'll probably say at some age he gets to control it, right? And it's considered his money if it's in that type of trust. So those are not options. The option is a third-party special needs trust. Now, that's the title, okay? It's what's written in the document that's really important. So somebody could give you a piece of paper and write special needs trust and call it that, but it's what's written inside of it. Just like my name might be Mary Ann, but what's in my heart and what's in my brain are me. That's what makes up me, right? It's kind of like a trust. A trust has you can be called anything. People call me May all the time as my nickname, but that's not who I am. It's what's inside of me. And so I'm going to talk about trust that way. It's what's inside of the trust that matters. You could call it anything you want to call it. But when Social Security wants to look at it, they're going to look at the wording inside of it. And that is the key. Okay. You have to have an attorney who understands this, who, yeah, I call it eats, sleeps, and drinks the special needs law so that you're getting it done right. But I'm just going to give you the concept of a third-party special needs trust. Third party, what does that mean? It means a person other than your child with special needs. So your child is the first party, and the third party is everybody else. It's the parents, it's the siblings, it's the aunt and uncles. It was not my son, but it's my son's brothers. All those kind of people can fund this trust, right? So it's funded by someone other than the person with a disability. I could put my inheritance into this trust. Savings that I want to set up for my son could be in that trust. And the trust's money is spent for supplemental care. Now, what does that mean? The government benefits are for basic support. So this can be used for something that the government can't pay for, right? So this money is for, if the government's paying up to here, this would be for something over and above it that my son will need. And then what happens to it? So there's all these players, okay? There's the person who it's for, that's the beneficiary. There's the person who sets it up, that's the grantor. You'll hear some terms, legal terms. There's the remainder beneficiary. Those are the people who get the remainder of the money after the person who had set up for passes away. So when you see the words PWD on my slides, PWD means person with a disability. So this trust is set up. When I pass away, money goes into it, or I can be setting it up while I'm alive and put money into it. And then when my son is, when I'm no longer here, that's the money that's going to provide for the supplemental care, that plus the government benefits. And then when my son passes away, who says where it goes? I do. I set it up. So I'm going to say, okay, maybe his brother gets some, maybe my granddaughter gets some, maybe the charities who help my son get some. I can choose to give it to whoever I choose. So I've set the rules, and there's people who are going to make sure the rules are followed. So first of all, it's a lot of paper. And people come into me with something, 2 pages, a 2-page trust. I'm like, if you've ever seen the rules of the road of how to drive, it's always a lot of rules. That's what I call about a trust. It's an instruction manual of how the money can be spent and how the trust can be used, but it's not 2 pagers. It's usually a pretty significant document. It has all the statutes in it and all the rules inside of it, right? And who sets it up? So typically it's parents, it could be siblings, it could be grandparents. Anyone can set this up. I could set up one for your special needs child. That would be okay. But my son can't set up his own. Okay, rule number one. Who's in charge of it? Well, it's who you want. So I can set it up and make me in charge. I could set one up and make my sister in charge. It's what I say. Who's in charge? We call them trustees. We trust those people to do what we need them to do. So in my case, I'm the trustee of my son's trust. I put in there if I'm incompetent or unable to act because I'm dead or whatever reason I can't act, I'm naming my sister to be the next trustee. And if my sister can't act, I will name one of my sons as the other trustee. And if they can't act, it would be a trust company. I put a corporate trust company on the back end. Now, as I've gotten older and watched people's ability to step in or want to step in because trustee job is significant, I've decided instead to make a niece a trustee for my son, along with a corporate trust company. Why? Because I don't want her to have all the work, right? I want her to be naming, being the person who's going to decide what's right and work with a corporate trustee who's going to do the tax returns, the administration of the money. And so if at stages in our life, we see people in different capacities of what they can do for us and for our child. And so picking those people is really important. But I call these people the money people. They are the people who are going to manage the money inside of this trust and decide how to do it. And the remainder beneficiaries are going to be the people who get the money upon the passing of my son. Okay, clear? All right. And typically, if I had two children with special needs, I would typically have two special needs trusts. Mostly it comes from my children. If I had children that had both special needs, they're different. And so I can decide at some point what that my son needs or both the son needs. If I put it in one big pot and tell the trustee to manage this as a pot, I'm leaving that future trustee to have to make the decisions of how much to use for each one. So I want to control some of that process, knowing that I have children with special needs and decide how much goes in each one. It's for supplemental care costs only, as I said. If the trust is funded, it must be irrevocable. What does that mean? It means I can't change it. Okay, it's irrevocable. I've done it. Social Security requires that because if it's revocable, if you set up a revocable trust and start funding it with money, and then later on I could change it so that it doesn't follow the rules anymore, that's a problem. So we want the attorney to create it as irrevocable. But I will tell you, I want to make sure that if the laws ever change, somebody can fix it. So the trust should have language that it's irrevocable or irrevocable when it's funded, but amendable to stay compliant with the law. So we don't want something to happen where they change the law and this trust doesn't accommodate that. So look for that language if you already have a trust, that somewhere in there does it say that this trust can be amended to stay compliant with the law, and any changes that are made would be backed. The date of it would be active as of the date the trust was created. Because sometimes what happens is not everybody understands what is going to happen in the future, and somebody becomes a trustee, and that trustee doesn't keep up, with the changes because they don't know, and the attorneys know, and they don't talk to each other all the time, and the change might occur, and the trust needed to be changed and it wasn't. But if they go back to an attorney, and the attorney is able to backdate those, that says any changes that are made are back to the beginning trust date of the trust, it allows anything in there to be retroactive. Okay, so some language you can look for if you have a trust. Now, people say to me many times, well, my child's only 10, I don't need to do this yet because it's about benefits, right? We don't want them to have any money. Well, the only thing I can say to that is, if your child is young and they're not getting benefits yet, something could happen to you before they're 18. And if you don't have the trust set up and you leave money to them, then it is too late because they already have money, and you can't then say, oh, I'm going to take it out of their name and put it in this other trust. There is something we could do, but it's not the advantageous way to do it. So when do you create the trust? The word now is in there and big on the slide, because acting and getting a trust set up, because we don't know what tomorrow holds, is very important. Oh, so how should you set up the trust? So I'm going to give you some basic terminology about trust. A trust is just language, is paper, it's just paper. Okay. So when do you go to the attorney and set that up? And how should the attorney set it up? So some attorneys will say, well, you're not going to use this until you die. So inside your will, I'm going to put some language that says, when I pass away, leave money to a trust that I'm going to create when I die. So the language is inside the will. That's called a testamentary trust. It is a will that is created in my testament. So when I pass away, it exists. Okay. My will says, when I die, create a special needs trust, put this money in it. I don't want this trust to be created inside the will or inside your trust at your death. Why? We want a sure thing. We want to know that what we're doing is going to be in place and nothing will undo this. Okay. We don't want to leave this to anybody else. We want to make sure it's taken and done now. So if I do it in my will, in between time now and the time I pass away, they say that you can't do these anymore. And then I die and they say, create one. If they don't let you create one anymore, well, we don't get one, right? So then all of a sudden we have put your child at a disadvantage in getting money in their name. They can't manage it. They lose their benefits. You want to work with an attorney who understands that concept and says, we are not going to put it inside your will, and we're not going to put it inside the documents you have for yourself, but we're going to create a separate document. So when I walk out of the attorney's office, I have signed something that says, Mark Ehlert Special Needs Trust. Okay, it has that name on it, has a date associated with the date I signed it. It exists. Two reasons. One, I want it grandfathered under the date on which I signed it. So if 20 years from now, they said, well, you can't have a special needs trust, my chance of them saying, well, I already had it. Okay, they're not going to take that away. It already exists. So number one. Two, piggybacking. What's that? Well, I'm going to set one up. Now my son has two brothers, right? And they don't have special needs. They might want to leave something for their brother, knowing that he can't have much money. They might want to set up a special needs trust too, or they might want to leave something. So if they're single and they have a job and they have 1 times their salary and they're going to get this life insurance if they die, they want to leave it to Mark. But they can't leave it to their brother Mark, because if he gets it, he'll lose his benefits. But they can, and they don't want to really go spend attorney fees on creating a special needs trust. Again, I've already set one up. It exists. I signed it. They can refer to it. They can refer and make the beneficiary of their life insurance on their job to the special needs trust set up by mom. Okay. So piggybacking is another reason to create a separate document. If I had it inside my will and my son wanted to leave something to that trust, he really can't, because the trust doesn't exist. So he passes away and the trust doesn't exist until I die. So that concept is a really important one. Okay, so I go to the attorney and I sign the document and I walk out with a book and it says special needs trust on it. Okay, Mark Ehlert Special Needs Trust. How do I get money in it? Do I open up the book and put money inside of it? That doesn't work. So remember, the trust is just a bunch of paper and it creates like a little company. Okay, the name of the company is the Mark Ehlert Special Needs Trust and it's got a date on it. So how do I get money in it? One, my will. So my will then, so I create the special needs trust first and I sign it. And then the attorney gives me a will for myself and the will refers to it. So the will says, when I pass away, put money in it. Or I have a trust of my own and my trust says, put money in the special needs trust. How else could I get money in it? My life insurance. I can have life insurance and the beneficiary of that life insurance would be the Mark Ehlert Special Needs Trust, not Mark Ehlert. Because if I make but this is where sometimes people make mistakes. I have a job, and if in my job I have life insurance, or how many have life insurance at their work, right? And we sign up on that first day of work and they give you the forms and they say, fill these out. So you go through and say, oh, good, I got 1 times pay or 2 times pay. And I ask you to fill out the beneficiary and you check the box that says spouse and then children. Mistake. Okay. If we have a special needs child, that form must not say that. That form must say my spouse, and then after my spouse, and it names my 3 children, but Mark's doesn't say Mark. Mark says Mark Ehlert Special Needs Trust. So in none of my documents can I refer directly to my son with special needs. Again, I always have to refer to his name with the words trust after it, right? And the date of the trust. Because if I give it to him, he'll lose his benefits. And Medicaid is really important to him. It pays a lot of his medical bills. Okay, retirement accounts. Everybody, we have to have a beneficiary on our retirement accounts, right? Our IRAs, our 401ks. So typically our retirement accounts are our spouse first. And actually, if we don't name our spouse first on a 401k, our spouse has to sign off with a notarized document that they're not taking it. So there's a lot of rules around that. But after my spouse, I have beneficiaries who are going to get it if my spouse isn't alive. And I can't name my son, but I can name his trust. So when I come out of the attorney's office, I'm not really done. I have to check everything that I have. And I can't tell you the number of times people forget that they have a small life insurance policy, or I forgot I had an IRA or had an annuity that has beneficiaries on it, and I named my children, and we've got to go back and check all that. Another way I can put money in the trust is open an account. It's kind of a weird concept sometimes for people to say, well, accounts can be opened. I can have an account in the Mary Anne Ehlert name. I can have a trust in Mary Anne Ehlert Trust, the name of the account that puts the money in my trust. I can also open an account that says Mary Anne Ehlert Trustee for the Mark Ehlert Special Needs Trust and put money in it, right? So I can leave money. I can have people want to make a gift. I can have them name it to the trust, and then I would open up an account in the name of the trust, and that, so it could be a savings account, it could be a mutual fund, it could be a brokerage account, it could be any kind of investment. Okay, so you're listening to me going, that sounds really good. And then you start thinking about what you've got, and you go back home and you think about it and you go, oh my gosh, we did something wrong. We have a trust already that leaves money to the child. You have to go back to your attorney and fix that. But what if you've already done something wrong? What if your advisor who's working with you at the bank or a brokerage house said, well, you have a child with special needs, you should start saving money for them. So you already have opened up an account or a custodial account where you're putting money away for your child. It is theirs. You can't just take it away. You already gifted it to them. It's theirs, okay? So what do? Because now you've undone thing. They're 15 years old. And now you're thinking about, okay, they can only have a house, a car, a prepaid funeral, and $2,000 and an ABLE account. What am I going to do? So there's another kind of special needs trust. Not everybody has one of these, but these are called over 93 trusts, a payback trust for a reason. And I sometimes call it oops trust. Oops, we got a problem. And so always think about that when you find out your child has money and their name is going to hurt them. We're either going to use one of these trusts, or if it's a small enough money, we can use an ABLE account, which we will talk about tomorrow in the next class. How does this trust differ? So we can set up this trust. It's got special language. Many times if there's a lot of money that's going to go into, we have to get approval from Social Security and from the court, and a lot of different processes that have to take place with this kind of a trust. But I'd like to talk about it here just so you are aware that it exists. Works very similar, except the money going into it. Remember the last trust we talked about? Let's go back to that diagram. Let's go back. What goes into a third-party trust? An inheritance from somebody and savings, okay? So now let's go back up to this trust and look at the difference. There we go. PWD's money, person with a disability's money, that goes into the payback trust. We couldn't go put that into the other trust. So we find we have significant funds in our child's name and we want to get it out of their name. There's a penalty for that. We're allowed to put it into this payback trust. It looks just the same. It's meant for supplemental care, but look beyond the bottom, second to the bottom of the section here. It says, at the person with the disability's passing, the trust must reimburse the state or states for benefits paid during a lifetime. And benefits means Medicaid benefits. So if my child's been getting Medicaid for 10 years, and Medicaid, let's say I spent $200,000 on them, and this trust had $500,000 in it for some reason, when my child passes away, the state's going to take their $200,000 back, and the $300,000 then will go to the remaining beneficiaries, but the state gets paid back first. And the really important thing about this trust, that the rules need to be followed, A. Secondly, payback order at the death is fees that have to be paid to accountants and attorneys in the state or whatever, things like that, that have processing fees, courts. And then secondly, the state gets paid back for Medicaid. And then the funeral can be paid. So I always say, if you have one of these trusts, the funeral can't be paid once the child passes away. And so prepaying the funeral out of this trust before they pass away is a good way to prepay funeral expenses. Okay. All right. And then the remaining goes to heirs. So big difference. The other money that can go into a first party trust, we call these first party trust or payback trust for a reason. First party because the money goes into it was the first party person. Can you have your child inherit money and say, oh, I'm just going to take it out of there and put it into the third party trust? No. Any money that goes into your child's name cannot go into the third party trust. It must go here. There's one other little nuance about this planning that is important. So child support, the divorce rate in different worlds is high. It's high across the board, but it's a little higher in special needs world, I think. I never really get good statistics, but I see a lot of couples who are divorced and wanting to plan. So child support can be paid sometimes for the lifetime of a child with disabilities. And so dad, let's assume in a typical world, it's not always this case because I have many clients who the mom is the one paying the child support. But the person who is a custodial parent gets child support. And while they get the child support when the child's under 18, the money belongs to mom or dad, whoever the custodial parent. But let's use dad paying the child support and mom being the custodial parent. So mom is getting this child support. And now the child turns 18. Who does that child support belong to? When the child's 18, it's their money. And if it's their money, the government is going to count that as income and they'll just get lower benefits. So in order to make this all work properly, the child support can be paid for the lifetime of the child, but it's paid by court order, with a court order, to a special needs trust. This special needs trust, not the third party trust. And so dad is writing checks into this trust. Mom is a trustee, and mom uses for the benefit of the child. Okay, so that's money kind of in and out. It doesn't accumulate in the same way. So if there's a payback on the death, usually that money is spent. All right. So just some nuances to know about. So here's just a diagram to let you see the big difference between two trusts and why you have to use the trust on the right if you don't have to. So if you want to make sure people know about leaving inheritances to the right place. So if grandma wants to leave something for your child, she doesn't want to leave it to the child because if she gives it to the child, we have to use the trust on the right once the money gets to that child. But if grandma leaves it directly to the trust on the left, there will be no government payback. It's important to have those conversations with the attorney. So if the attorney is asking you lots of questions about who's going to be trustees, the attorney should also be asking you, are there other people who might be leaving your child an inheritance? And they will help you communicate with a letter from themselves that you can use to pass on to other people, like the siblings or the grandparents or the aunts and uncles, because sometimes we're a little hesitant to go to our other family members and say, hey, if you want to give my child some money, here's how you can do it. The attorney sometimes will give you a letter that you can use with family members saying, if you were to leave something to this child. Now, sometimes I will have a family meeting with a client and grandma and grandpa come in. And I tell everybody, if you want to bring your legal documents so I can quickly look at it and see what you might have to do with the attorney. And so grandma and grandpa are sitting in the meeting and I say, if you're going to leave anything to Mark, don't leave it to Mark, please leave it to this trust. And the natural response from grandma and grandpa are, well, we're not leaving anything to our grandchildren, we're leaving it to our children only. Well, there's a risk there, right? Because if my parents were going to say they're going to leave an inheritance to me, and I'm not alive, their document says leave it per stirpes, and per stirpes means down the bloodline. So if something comes to me and I'm not alive, it could go to my children. And one of my children being Mark, he could get some inheritance from grandma and grandpa, even though, nobody thinks that the parent's going to die first, but that happens and we know it happens. And so we want grandma and grandpa to change their documents to say that the beneficiary is if any grandchild is going to get this, and Mark in particular, it should go to his special needs trust in case he were to get it that way. Okay. So how do you find one of these attorneys? How do you find an attorney who knows this? We have a link on our website, but there are lots of other places to get it as well. You can go to NALA, the National Academy of Elder Law Attorneys. There's the Special Needs Alliance. There's the Special Needs Planners. There's all these websites that have special needs attorneys. You want to make sure the attorney does special needs law. You want to make sure they don't just work with seniors, but they work with families who have disabled children. And it's very important. So there's attorneys who know a lot about it. They're the gurus, okay? Maybe you need that. There's attorneys who know nothing about it. They're going to know to send them to the guru. And then there's the people in the middle. The people in the middle, there's a carved out group of them that know just about as much as the gurus, okay? The gurus are just the ones who started it. Then there's the next group who know it. Then there's this group who don't know it at all. And it's the danger in our world is not knowing what you don't know. So attorneys always nobody ever tries to make a mistake. But there are people who, just like me, there's part of financial planning that I don't do. Okay. I know who the experts are. And so if I have a really complicated IRS question or something having to do with investments, I'm going to go to that advisor who I know who's the guru. I'm going to find the people who know what I don't know. And if I don't have an expertise in it, I'm smart enough to say, I don't know, I'll find you somebody. There's some attorneys out there that think they know it. You've got to make sure that they really know this deeply, because a small mistake could cost your child their benefits. Okay, so we talked about the financial stuff. Let's talk about some other hard decisions. So on the financial part, you're making decisions about money. Now we're going to make decisions about care. If I am the guardian of my child, or will be the guardian in the future, I have to put into my legal documents, who's going to take over my job? This is the hardest decision. Sometimes I would go to attorneys' meetings with clients, and we would go to the attorney, and the attorney says, well, who's going to step into your shoes? And the client gets so panicked that they never want to go back. And so I'd like to do these classes so you're thinking about who are the people, so that when you go to the attorney's office, you have the list of people to discuss as potential people who could act in this capacity. So these, remember I said there's money people and care people. This is when now we're talking about who's going to step into your shoes and the responsibility of care. Who's going to make medical decisions, who's going to make those government benefit decisions and employment and day programs and care and support. The team that we need, the team needs to be directed by someone, and that is the future guardian. So the people you're picking, can they understand what you're asking of them? Do they understand that if they're on vacation, they still got this responsibility? Do they understand that the job's going to outlast them? They're going to have the job, and when they die, they're going to have to designate the next person after them. Once they get the job, they're it. It doesn't go back to your legal documents and say who's the next person after them. They get the job. Once they get it, they're going to name their successors. Okay. It should be a married couple. Should it be your brother and his wife? Or should it be just your brother? Or should it be just his wife? What if they get divorced? What do you want to have happen? By the time you pass away and they're not married anyway, and your documents say you want it to be the couple, what's going to happen? So what you put in your will and who you name as the people you want, they automatically get the job. No, you are nominating them. We all know in the political system, you can be nominated, but you don't always win the election, right? So you're nominating them in your will. They still have to go to court. They still have to prove to the court that they're the right people for the job. Everybody in that family gets notified that this person's going to be applying for the job when they go to that court process for guardianship. Okay. In some states, it's called conservatorship. So is it the married couples? Who should be? You're nominating them. Don't just nominate one. In your will, you're going to say this person and then this person, or maybe if the siblings are a certain age, I want them to be considered first. Should they be the same people as the trustees? So remember, in the trust, we picked people who are going to take our job after us as the money people. So should I have one person doing the money and the care? Should I have co-trustees and then maybe a guardian? What should I have? So thinking about those people, these are the conversations you have with the attorney. But if you go to the attorney's office with these are the 5 people I'm thinking about, you'll have a better conversation. Sometimes people say, I just don't know. Who am I going to pick? Well, if you don't pick anybody, the court will decide. Is that what you want? The court? I don't think so. So I say go through an exercise. For the trustee, sit down with a piece of paper, put a timer on, and say, write down really fast in 1 minute all the people you know who are good with money. And then circle those people's names that you wrote who care about your child, and then put them in order of 1, 2, 3. That you got to start, right? Same thing with the guardian. Put down all the people who you know who are caring and loving. And then secondly, the ones who are caring and loving about your child, put them in order of 1, 2, 3. Sometimes it's other children, sometimes it's your siblings, sometimes it's other parents, but you've got to do this process. You can always change your will. You can always change your future trustees as long as you have capacity. All right. There's one more thing I want you to think about that's a legal process. What happens when your child reaches the age of majority? So up to the point of 18, you're making all the decisions. When they're 18, they're making all the decisions, unless you do something about it. So one, you could do nothing. And if you do nothing, you have done something. You said your child has capacity to do something, right? Two, if you do nothing, you should at least, then you're assuming that your child has authority and capability to make decisions. So they should be signing pieces of paper that an attorney prepares, where they will sign and say, I'm giving my mom and dad some rights. Okay. I'm giving them rights to help me make decisions, because otherwise it's all on them. And you'd have to prove that it's not all on them. And then you're talking about going to court. So if you know when your child turns 18 that they can't make medical decisions, they can't make financial decisions, then it's a guardianship process or a conservatorship process, depending upon where you live. And that process is a court proceeding. You are getting medical reports from the doctor, you're going to the judge, and you're saying this person doesn't have capacity to do certain things. And once you become the guardian, then you report to the court. Once a year, you fill out reports to say this is what's going on with this person. It's the court's job and the judge's job to make sure that you are doing your job. Okay. And it's hard. If your child's high functioning, when will they get themselves in trouble? What kind of help are they going to need? You're taking their rights away. So you don't do this lightly. In some cases, for my sister, it was an easy process. She didn't have the competence to make any of those decisions, and she definitely needed a guardian. But in some cases, it's tough. It is tough. Okay. So one other question the attorney will ask you, and sometimes people struggle with this one. I call it the head versus the heart. The attorney says to you, how do you want to split your money? Her heart says, equally, of course. There's 6 children. I want to give it to them equally. And my parents went through this. But their heart is speaking, but our head sometimes is saying, wait a minute, you really can't do that. And if you have $1 billion, do equally. But if we've already calculated what your child needs, and it's more than half of your money, or it's more than 1/6 of your money, how do you make that decision? So sometimes it's easy. Sometimes you have enough. And the share that your child's going to get going into their special needs trust is based upon your assets enough. But what if it is not enough? What do you do? So sometimes people say, well, I have 3 children. I'll get 50% of the special needs trust, 25% to the other 2. And the special needs trust, if there's still money left when they pass away, it will go to the trust. What if I just leave it all to the special needs child? I said, I'll leave it equally to my children, and I'll have a separate life insurance policy to fund the trust. That kind of meets both my needs. My needs are different than your needs. So it's important to think that through. Now, our next class is going to be about the ABLE Act. Some of you will be doing this in order. Some of you will be doing them just signing up based on what you see. But we're going to be talking about the ABLE Act in detail. And that's a fun one too. It's got a little complicated, but once you understand it, it's a great tool. All right. So a couple homework pieces here. What did you learn today that you need to do? And then when we talk about the document, the wonder, the step of communicating to your family, who do you have to tell? Okay. Every class we're going to say, who do you have to tell about what you learned today? Who needs to be communicated with? And how do you write it down? You'll go back to your My Special Life and say, I have a special needs trust. This is where it's at. Here's the attorney, and it's part of your team. So you've got to tell people about it. So again, as we finish each class, pull out your little gift card. What is the first step you're going to do from this class? Feel free to email it to us, to me, based upon the email address we give you, info@protectedtomorrows.com, and we'll hold you accountable. What are you going to do? When you're going to see the attorney, you're going to pull out your trust and check it out. You're going to find an attorney in your area. You're going to start writing down names. What do you think you're going to do? All right. I want everybody to take some action. So thanks for listening, and happy legal planning.
Okay.